Welcome to this edition of Diligence Inside America's Boardrooms. I'm TK Kerstetter, and I'll be your host for today's show. Today, we're going to be talking about, can a stakeholder-centric corporate structure function within Delaware corporate law? And joining me is Randy Holland, who's a former justice with the Delaware Supreme Court and is also a Wilson Sonsini Senior of Counsel. Welcome, Randy.
Thank you. It's nice to be here.
So it's no secret to you that there's been quite the movement this year with stakeholder capitalism, and everybody's looking at sort of moving away from primarily this shareholder-centric and moving to this concept of stakeholder, which takes in other major constituencies into the process. Again, I'm not sure that it's terribly new, but the emphasis on it certainly raises some questions. And when you think about the Delaware courts, you think about their support of shareholder and corporation rights, and you look at cases that have fallen back on certain rights and board issues and what their duties are, et cetera, et cetera. And now all of a sudden you have major emphasis on sort of not profits ahead of shareholders and other constituents. You look at environment, you look at the concern as it relates to employees and even communities. Again, you and I know this is nothing necessarily new, but the pressure on this, and when you think of what may happen when issues come to the court, talk a little bit about how there's a balance between Delaware corporate law and this movement of stakeholder capitalism.
Well, I think it really calls upon the Delaware courts to apply well-established principles of Delaware law. So if we go back to the mid-1980s, there are two cases that are particularly relevant and maybe frame my answer. One is the Unical case, where the board was defending against the takeover, and the Delaware Supreme Court said unequivocally that in defending the takeover, the board could consider stakeholders, creditors, employees, other constituencies, and even the community. And so there's no doubt that in doing what the board thinks is best for the corporation, they can consider stakeholders. Now, the second case is Revlon, which says when the company is for sale, you have to achieve a price that's the highest price available for the shareholders. So when the company's being sold, the sole focus of the board is the best price for the shareholders. But most companies aren't being sold. So what you're doing is operating a company, and you're permitted to consider stakeholders' interest. You have no fiduciary duty to them, but you can consider them. The fiduciary duty is to the corporation and the shareholders. Now, the question is, when you're acting in the interest of a stakeholder, how will the courts look at it? And the operative word there is action. And that brings to mind and into play the Delaware Business Judgment Rule. The Delaware Business Judgment Rule states that whenever a board takes action, the Delaware courts will presume that they did it with care, on an informed basis, and in the best interest of the corporation. So that's really the question. Can you defend whatever action you take in the interest of a stakeholder as being informed, loyal, and with due care in the best interest of the corporation? Now, if we want to take an example of something that may not look like the best interest of the stockholders, we could look at philanthropy, which the Delaware courts have recognized is a legitimate business action defended under the business judgment rule. When you're giving away the money of the corporation, it's obviously not going to the shareholders, but it's deemed to be in the best interest of the shareholders in the long run to generate goodwill through philanthropy. So I think these decisions today about stakeholder interest really bring into focus the shareholders' interest in the company. The Delaware courts have said that the board can manage the business of the company for the long run. They don't have to realize profits in the short run. But to the extent they want to take action in the short run that's not profitable, they have to be able to defend it as the best interest of the corporation in the long run. So the tension I see developing for directors is whether the shareholders are going to tolerate stakeholder action in the short run that they think is not profitable because they don't want to wait for the long run.
Well, it's going to be interesting to see what happens in early cases. For example, if somebody closes a plant, or if they make a decision that might be good for the corporation, but will not be good, certainly for the employees that work at that plant or something like that. I think that there'll probably be some, don't you believe that there'll be some early cases that sort of set up these parameters around issues like that and start to set up a framework?
Well, and I think in your question, you said it may be good for the corporation, would be good for the corporation, but not necessarily for the employees. If the board does research, acts on an informed basis with loyalty, and decides it's in the best interest of the corporation to close a plant, and that will be totally defensible under the business judgment rule, and the directors will have no problem closing the plant.
Now, all that said, that doesn't mean that there won't be lawsuits connected with this. And again, that's where I guess I'm speaking to the framework that, we'll find out what happens relative to how many people go that path.
Exactly. Well, and as you know, the burden is on the plaintiff in a lawsuit to show that the board's action was not in the best interest of the corporation. So the plaintiff has to go first and marshal the evidence that the board did not act with care and the board did not act with loyalty, and that closing the plant was not in the best interest of the corporation. But to the extent the plaintiffs were employees, it would be their burden to rebut the presumption of care and good faith.
So certainly this stakeholder capitalism is putting pressure that should have been there before, but certainly pressure to be thinking through these decisions about what happens, because investors and activists are going to be much more sensitive to what's happening. But you mentioned about, the duties, and, the Delaware courts have always fallen back on the duty of loyalty and the duty of care. Does this stakeholder capitalism, you've always heard about the duty of good faith, which never is formally discussed, but is another duty. Is there anything that capitalism in any way changes duty of loyalty or duty of care, or should there be additions to this responsibility?
I don't think it changes them, but you raise a very good point, and it relates to shareholder activism. So if we go back to the hypothetical of closing the plant, let's suppose that the board of directors decided not to close the plant, even though it was not profitable. They decided to keep it running a little longer. What we can see is an activist shareholder interested in capitalism and a return, putting pressure on the board to close the non-profitable plant when the board thinks it's in the best interest to keep it going a little while longer. Assuming the Delaware court finds the board's action to be defensible and the presumption of the business judgment rule is not rebutted, then what the Delaware courts would say is the only remedy for the activist shareholder who wants to close the plant is to replace the board of directors. And that's really what we're going to see in the future. To the extent the boards can defend action that's favorable to the stakeholders, but may not be profitable in the short run, there's going to be tension about whether the shareholders are going to tolerate that or want to elect a new board.
Well, and that leads in a whole nother topic that we'll have to save for another show, and that talks to the importance of the minutes and the actions by a board and how that can play such a major role in making sure that they, quote, did their due diligence prior to making an important decision like that.
No, you're exactly right. And the emphasis in the Delaware courts is on process. And the board has to demonstrate that its deliberative process when it took action is defensible under the business judgment rule.
Well, Randy, I want to thank you for taking the time. I think this is certainly not going to be an issue that is not without some consternation as everything gets sorted out. Again, with the propensity of some groups to, put pressure on board or feeling that they are negligent in their duties. So we'll have to see. I suggest that both the Court of Chancery and the Supreme Court will have their fair share of cases to set up some guidelines and roadmaps for. But I want to thank you again for taking the time to at least get us started and understanding that there's not an inherent conflict with any of this.
It was my pleasure. Thank you for having me.
And that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take another look at a critical topic that'll help you be a better board member or committee member. So we'll see you then.